website. We encourage you to ask questions throughout the entire presentation by submitting them using the chat feature. Submit those to everyone in the chat. And if you prefer to remain anonymous, just send your questions to the meeting host, Carrie Fliss, and she will post them on your behalf. So feel free to do that too. The speakers will set aside 10 minutes at the end of the presentation to respond. So now I'd like to briefly introduce you to Michael, Young-Soon, and Natasha, our three speakers today from Akin Gump. Michael's a litigator in Akin Gump's San Francisco office who focuses on defending companies in consumer class actions, including class actions under FCRA and similar federal and state statutes. Michael also counsels companies on mitigating or reducing class action risks, including through the use of consumer arbitration provisions in the customer terms of use. Young-Soon is a litigator in Akin Gump's Irvine office. So he's coming to us from Southern California. For 2 decades, he has defended clients in complex and high-stakes consumer class actions and product liability litigation across a range of industries, including electronics, food and beverage, retail, oil, gas, and private equity. Young-Soon also advises companies about compliance with federal and state data and data privacy statutes, such as FCRA. Natasha is co-head of Akin Gump's cybersecurity, privacy, and data protection practice and has 2 decades of experience assisting clients in navigating the evolving risk in privacy and cybersecurity regulation, enforcement, investigations, and class action litigation, including related to the CCPA, VPPA, FCRA, and other consumer protection statutes across the country. She also assists clients in conducting comprehensive privacy and security risk assessments and develops policies and procedures to mitigate and remediate privacy and cybersecurity threats. Natasha has been recognized as one of California's top cyber artificial intelligence lawyers in both 2018 and 2019. She is also recommended by the Legal 500 US in cyber law from 2017 to 2020. So with that, I'll hand it off to Natasha. Thank you again for being here, and thank you again to Akin Gump for your amazing sponsorship. Thank you.
Thank you so much, Alex, and thank you, ACC, for co-hosting this event with us at Akin Gump. Good morning, everyone. We appreciate you taking the time to join our webinar today, and as mentioned by Alex, please feel free to send questions via the chat, and we'll try to pick them up towards the end. So we're going to get started. Next slide, please. Next slide. So over the last 10 years, since 2010, we've seen an increase in the filings of FCRA lawsuits. And you can see on this graph here, this steady rise in FCRA filings year over year. And when you look at these stats and compare them to other consumer protection statutes, FCRA has clearly been the most consistently and increasingly used over the last several years. So for example, the TCPA, the Telephone Consumer Protection Act, and the FDCPA, the Fair Debt Collection Practices Act, were all popular statutes that grabbed plaintiffs' lawyers' attention, and they hit their peaks over the past few years. TCPA's peak was around 2016, and the FDCPA had a run in 2011 and 2015, but overall these cases have been decreasing, and we just haven't seen the same increase in lawsuits year in, year out for this prolonged period of time as we have seen with FCRA. Next slide, please. And in 2020, even with the initial slowdown of cases during the early stages of the pandemic, FCRA filings from January to the end of October 2020 numbered almost 4,400, which is a 5% increase from the 4,100 FCRA filings during the same time period in 2019. So it's projected that FCRA will end the year with around 5,200 filings, which is around 250 more filings than in 2019. And yet that means, yet again, FCRA filings will have increased for the 10th year in a row. Then there's the CARES Act, which was the Coronavirus Relief Act that we'll discuss a little bit later on. That amended FCRA and opened up more opportunities for businesses to be sued. And under this new amendment, credit reporting agencies are supposed to report delayed payment obligations as current, which complicates the accuracy obligations of consumer reporting. So we're going to discuss with you our theories as to why FCRA has sustained the interests of plaintiff lawyers longer than some of these other statutes, and also update you with what's going on with FCRA under the CARES Act. Next slide, please. So we're going to set the stage and go over some basics. FCRA was enacted by Congress in 1970, and it was aimed to promote the accuracy, fairness, and privacy of consumer information in credit reports. And at first, FCRA was really originally directed at the conduct of credit reporting agencies, but later it was amended to impose extensive responsibilities on furnishers and users of consumer credit information. So a furnisher is someone who provides information to the credit reporting agencies to include that information in consumer reports. So that would include banks and credit card issuers and collection agencies. And then users, which is probably most of you here on this video conference, are persons that receive consumer or credit reports, and that's whether you obtain it directly or indirectly from a credit reporting agency. Now, users of consumer reports have a number of requirements to follow, including notifying consumers when adverse actions are taken based on the consumer report, ensuring there's a permissible purpose to obtain the consumer report, and providing employees or applicants with clear and conspicuous disclosures in writing. And I think Young Soon will get into these disclosure topics a bit later. Young Soon?
That's right. Thanks, Natasha. And I'll also say most of this presentation will focus on some of the requirements in FCRA that apply to users, although Mike will be speaking later in this presentation about some of the requirements for both furnishers and the CRA. We'll also say, to the extent that you have a particular question, whether it's from a perspective of a CRA, a furnisher, or user, you don't feel comfortable addressing to the group or to us in this forum, we're happy to answer those questions offline as well. If we turn to the next slide, I'd like to give a brief overview, broad overview of a typical use case involving employer background checks under FCRA. Essentially, what circumstances might a company be liable under FCRA for receiving a credit check or other background report on a potential employee? We'll go into each of these elements in more detail, but I'll start with an overview. The first element is you need to be receiving information from a consumer reporting agency. If you're a user of information under FCRA, if you're not receiving that information from a CRA, then you're not subject to FCRA's limitations. Under FCRA, a consumer reporting agency is anyone that, in exchange for some kind of compensation, regularly assembles or evaluates consumer credit information or other information on consumers for the purpose of furnishing consumer reports to third parties. The definition is tied to the furnishing of consumer reports. So companies whose business is assembling and providing background checks, those are the companies that are most likely to be a CRA. Private investigators, often considered CRAs. An independent contractor who does all kinds of work for your company, then is asked occasionally to pull up information on a potential employee, likely not a CRA. Watch out, I would say, for sources of information like data aggregators or companies that operate public databases. Often these companies will disclaim being a CRA under FCRA, which, believe it or not, is actually relevant to whether you are a CRA. But do be careful because the law is a bit mixed. Sometimes a data company can have multiple databases housing multiple types of information. For purposes of housing a public record database, the company might not be a CRA, but for purposes of housing a credit check database, that same entity might be a CRA. I would also watch out for certain state laws that may apply even if you are not getting information from a CRA, right? This presentation is about FCRA, but California, to give an example, has a law, the Investigative Consumer Reporting Agencies Act, and certain disclosure requirements in that act do apply even if you're not receiving information from a CRA. The second element, whether you're receiving a consumer report, Mike's going to cover in a bit more detail moments from now. If those elements are satisfied, then the question is, are you properly disclosing to the individual whose information you're obtaining the fact that you're going to get the consumer report, and are you obtaining consent? We're going to talk about that in a little bit. And if you are not doing so and you are subject to FCRA, your receipt of the information is subject to FCRA, then you may potentially be liable for damages, actual and potentially statutory. So Mike, you want to tell us a little more about what a consumer report is?
Yeah, thanks, Jung-Soon. Appreciate it. So we've put up there the statutory definition. The really critical guardrail here that we see in litigation and also sort of analyzing how companies comply with the statute. The guardrail is that the report is generated to establish the consumer's eligibility for consumer purposes, essentially for personal, family, or household purposes. So there's guardrail in the sense that if the report is generated or used for business purposes, that is not subject to the FCRA requirements that we're going to be detailing. This is kind of a classic example of something that's inherent in the definition of consumer, but the courts have put the consumer report requirement into FCRA and have enforced this requirement based on the legislative history. There's pretty robust case law from the circuit court and district court level. The example being if the plaintiff sought financing for a joint venture or some loan for a business that they were launching, the FCRA doesn't come into play if the lender is using the reports to analyze that application. And that's a key distinction, and it's one of the few kind of bright lines that are out there when you're talking about the nuances of the statute. Will we go to the next slide?
Yeah, we're going to go now into the expansive remedies available under FCRA. One of the main reasons FCRA is such a popular statute for plaintiffs' lawyers is its private right of action and the expansive remedies available. FCRA's private right of action covers any violation of FCRA with some limited exceptions for the accuracy of information provided by furnishers and users and their related disclosure obligations. Now, FCRA is not a strict liability statute. It imposes civil liability for negligent and willful violations of the statute. Now, for negligent violations, actual damages and attorney's fees are available. And actual damages can include damages for emotional distress. But for a willful violation, a plaintiff can recover actual damages or statutory damages of not less than $100 and not more than $1,000 per violation. And there's also punitive damages and attorney fees that are available. Now, what it means for a violation to be willful is of intense interest given the potential for statutory and punitive damages. And the Supreme Court weighed in a case called Safeco, noting that willfulness depends in part on whether the company's interpretation of the statute was unreasonable. And so what followed from that is that if you commit a clear violation of an established principle of law under binding case authority, a court will more likely find that you have committed a willful violation. And the Ninth Circuit reiterated this a few years ago. It noted that if a party's action violates an unambiguous statutory requirement, this fact alone may be sufficient to conclude that its violation is reckless and therefore willful. And I think Young-Soon will go through in a little bit some examples of some unambiguous statutory violations of FCRA, like including certain extraneous information in your disclosures. There is a recent case out of the 11th Circuit that speaks to this issue, and the background is that in May of 2018, a jury awarded punitive damages to a plaintiff in Alabama for a defendant's alleged willful violation of FCRA and the defendant's refusal to reinvestigate plaintiff's disputed debt. Now, the defendant here had a suspicious mailroom policy, and what the plaintiff did is they sent a letter disputing the debt. But the defendant believed the letter to be suspect and diverted the letter and informed the plaintiff that it wouldn't investigate the debt. And the jury found this to be a willful violation of FCRA. But earlier this year, the 11th Circuit reversed the willfulness jury verdict, falling back on the Supreme Court's ruling in Sufeco and holding that there was no reasonable basis for, or no basis for a reasonable jury to find that the defendant knowingly or recklessly violated the statute. So essentially, the 11th Circuit found that the plaintiff had not presented clear and convincing evidence necessary for a reasonable jury to award punitive damages. And this is especially in light of the other counterbalancing duties imposed by FCRA, which included, guarding against fraud and handing over the consumer report for an impermissible purpose. Next slide, please. Okay, we're going to get into some of the latest issues in litigation, but I did want to mention some of the regulatory activity over this past year. In addition to the private right of action, FCRA is also enforced by the FTC, the CFPB, and the state attorneys general. Now, the FTC brought one of its first cases under Section 609 of FCRA just this past year, relating to the rights of identity theft victims to obtain business records where their personal information was actually involved in the theft. And in this case, the retailer Kohl's was fined by the FTC for allegedly failing to provide victims with complete records of transactions that were used by the thieves to steal their personal information. And the director for the FTC's Consumer Protection Bureau noted that this case is a warning to other companies and that the FTC will hold you responsible if you fail to give identity theft victims their required business records. In addition, both the FTC and the CFPB separately issued some guidance on the use of artificial intelligence and algorithms earlier this year. The FTC in particular warned that a company that assembles consumer information and uses automated decision-making to determine eligibility for credit or employment or housing or similar benefits may be deemed a consumer reporting agency, and that in turn could trigger duties on the part of the user of such information. So, for example, if you purchase a report from a company that uses AI tools to generate a score that predicts whether a consumer would be a good tenant, and then if you use that information to deny the tenant housing or to charge them higher rent, then you might have to provide that consumer with an adverse action notice. And as noted earlier, who would be considered a consumer reporting agency is getting more and more complicated as data aggregation and analysis proliferates. And as a user, it would be important to look at some of these implications. Next slide, please. So that leads me to how FCRA intersects with data privacy laws that are popping up around the world. And in addition to this very intricate statute of FCRA, the CRAs, the users, the furnishers, they need to be careful about these new imposing obligations under emerging data protection laws. Now, yes, under the CCPA, there is an exemption for eligibility information, and that's essentially information that bears on an individual's creditworthiness. And so such eligibility information is exempt from the CCPA, but that's only to the extent such information is used for purposes of FCRA. And this exemption primarily came out of the 2019 amendments to the CCPA. And it's notable that the founder of the CCPA, Alistair McTaggart, was upset by some of the amendments introduced in 2019. And as a result, he pushed to the ballot the data privacy measure, the California Privacy Rights Act, which ultimately passed and imposed additional obligations on businesses. And he did this because he believed that special interests and lobbyists would end up ultimately watering down the protections in the CCPA. And it's not clear if the FCRA amendment was one of the amendments that he was unhappy about, but the CCPA does stand in stark contrast to the GDPR, where no such exemption exists. And the CRAs and other companies need to comply like any other company. And that means, a company would have to respond to data subject requests like access and deletion requests. And in fact, there's already an enforcement action by the Spanish DPA who fined a company for refusing to delete data that came from a data subject request in relation to that individual's credit reporting information. Also under the GDPR, under certain circumstances where automated processing is involved to determine if credit should be extended, a company might have to run a data protection impact assessment. And I think the main point here is that those companies that have to comply with FCRA will also continue to have to comply with increased data protection regulation now and in many years to come. So finally, I just want to note very quickly that there are some federal legislative proposals pending and important to look out for. There's 13 different legislative proposals in Congress right now proposing to amend FCRA, many of them focused on protecting consumers and ranging from protecting students who defaulted on loans or patients with substantial medical bills. There's a security amendment proposing to grant the CFPB authority to oversee the cybersecurity efforts of CRAs. And so depending on the makeup of Congress and if Democrats win the Senate, some of these proposals might get over the line. If not, as we'll discuss a bit later, we do anticipate more aggressive action at the CFPB and the FTC on enforcement and rulemaking matters. So now I'm going to hand it over to Young Soon to discuss employee background checks.
All right, so what I'm showing here is a sample background check disclosure form. And what I want to talk about a bit is what disclosures FCRA requires if you're going to obtain a background check in the employment context. So let me ask you this. I know in this kind of situation, folks can be a bit shy in terms of raising their hand. Not going to call on anyone, but I am showing you what is in many ways a typical disclosure form. And my question is, do you see anything wrong with this? If you do and you want to volunteer something, feel free to put into the chat to everybody. If you look at the form, you see it has language about what the company would obtain, and it looks like someone's already given the answer. Excellent. What the company can and cannot do under FCRA and state law, and then the consent and authorization. This appears to be a fairly straightforward form. I will say this form resulted in a class action lawsuit that ultimately ended with the company agreeing to pay $2.3 million to settle claims. And the answer, as someone has pointed out in the chat, is the combination of federal and state law disclosures in the form. That is impermissible in the Ninth Circuit and arguably elsewhere. Let's move on to the next slide. All right, this one's particularly interesting because it's a sample of an online form, which is something that a lot of companies are moving to. So again, if folks see anything wrong with this one, feel free to type it into the chat. As I said, it's an online disclosure form. There's a scroll through containing the authorization. We've only shown you the first part of the scroll through. And I'll say Here, this form resulted in a class action lawsuit that the company paid $6.8 million to settle. So the issue here, and it may be a little bit hard to see because the text is a bit small, is the last line that you see of the scroll through, which is the release of liability. It is not permitted, according to fairly clear law in the Ninth Circuit, to include a release of liability in the same form as the disclosure. The point here, I think the broader point that I'm making here is read your forms carefully, know the law, because what appears to be innocuous language can land you in a good deal of hot water. And as Natasha mentioned, and as I believe Mike may be elaborating on a little bit later, when the standard is clear under the relevant binding authority for what can be on the form and what cannot, not only does that potentially result in liability under FCRA, but it also can lead to a finding of willfulness, which is required to impose statutory penalties or damages. Next slide, please. So here's the basic disclosure requirements. If you are going to obtain what is called a consumer report from about a potential employee from a CRA, the disclosure needs to be clear and conspicuous. It needs to be in a document that consists solely of the disclosure, and the disclosure needs to explain that a consumer report may be obtained for employment purposes. The piece of this that is, I think, most often problematic for companies is well, it's actually two parts. It's the in a document that consists solely of the disclosure, which can be a bit vague, and then clear and conspicuous. Those two things can be tied together. There are certain things that are clearly not allowed. Do not combine FCRA disclosure with a disclosure under state law. Do not do that, as the Gilbert case has already decided. Do not include a liability waiver in the same document as a disclosure. That's the Syed case. Can you include the authorization in the same document as the disclosure? Yes, you can. That is the consent. But minimize the information that's provided with the authorization, right? Sometimes you'll see a form that has a box for authorization that then asks for a lot of additional information from that individual. Their address, their contact information. Be careful. As the Ninth Circuit said in the Walker case earlier this year, if the verbiage in your form pulls the applicant's attention away from their rights under FCRA, you are in danger of running afoul of FCRA. Providing additional documents in the same packet as the background check disclosure, you can. Again, there are nuances there that we'll get to. And then the online disclosure, which we've already looked at a sample of, and which is, in my view, a place where you have to exercise particular caution because you don't have the natural page size limitation. And you can do things like a scroll through where you can put a lot of information on a single page. The temptation can be to jam a lot of information onto a single page. Don't do it. There's also, I think, an open question as to whether clicking through several screens amounts to one document or multiple documents. I think the stronger position is that they are multiple documents, but to even avoid that question, you want to make very clear using titles, headings, etc., the way that a person clicks through from one document to the next or one page to the next, that the FCRA disclosure is a standalone document. Okay, next page, please. So the good news is that the Ninth Circuit this year did ease, or at least slightly relax, provide a slightly relaxed interpretation of FCRA in the Walker and the Luna cases. I think the Walker case is particularly interesting because even as it explained how certain types of information described there can be combined with the disclosure, it also has this warning that I had mentioned earlier, right? That if the information pulls the applicant's attention away from the rights provided under FCRA, that can constitute a violation of this standalone disclosure requirement. And so what you see in this, in Walker, is the Ninth Circuit going disclosure by disclosure in the form and saying, this is okay, this is not. This is okay, this is not. That's the approach that courts, at least in the Ninth Circuit, which really is kind of leading the charge in terms of these issues, is taking. And so that leads me to the next slide, and I think the most important practical point that's already been kind of echoed here, which is go overboard. Err on the side of caution in separating out your FCRA disclosure under federal law from everything else. Avoid the temptation to include really anything other than the basics of the FCRA disclosure in that same form. And again, we're happy to discuss particular scenarios. If you have questions, you're welcome to put them in the chat or discuss with us afterwards. I mentioned electronic disclosures. Again, that's a place where you want to exercise particular caution. And we've noted, and I think someone had a question about the particular statute that could apply even where information is not being received from a CRA. One such statute is the Investigative Consumer Reporting Agencies Act, ICRAA, in California, which says that if you are receiving what are defined as public records, those types of, as the statute defines them, you do have to undergo certain procedural steps before you can receive and use those types of records, even if you're not doing so, even if you're not getting that information from a CRA. I want to briefly talk about involvement in third parties' employment decisions. This one's kind of interesting. I think, let's say you work at a private equity fund that owns a stake in a portfolio company, right? You receive information from a CRA about the CEO of the portfolio company that you work with, that in which your fund has a stake, and you want to use that information to affect the CEO's employment status. Can you do that under FCRA? Perhaps, but caution. There's an argument that FCRA applies, at least based on certain cases in New York and California, that FCRA applies in circumstances that go beyond the typical employer-employee context, right? So the term employment purposes, when used in connection with FCRA, means the purpose of evaluating a consumer for employment, promotion, reassignment, or retention as an employee. It doesn't say that they have to be an employee of your company. And there are cases that have applied FCRA to independent contractors and similar folks who are not a direct employee of the company. And so I would exercise some caution in that circumstance as well.
The next prong that we are going to look at is for customer-facing businesses. Next slide. And the FCRA terminology here is users of credit reports. And what this slide lays out is just sort of the general flowchart that the statute and the courts recognize. There's really, in contrast to some other statutes, FCRA doesn't necessarily require as a user of credit reports that you obtain the written authorization of the customer. So if you do have that, that's one way to obtain permission to use the reports. But there's, and this is where we see a lot of the controversy and litigation, separate channel, and that is if you have a legitimate business need for the credit check. And there's at least two statutory prongs that recognize if you are considering a business transaction initiated by the consumer, or if the consumer has an existing account and you're reviewing it to see whether the account is current for payment or otherwise meets the terms of the account. And that's really where we see a lot of the activity around the legitimate business need. If we could go to the next slide, please. The scenario we see, not surprisingly, very, very much in this day and age is the scenario of identity theft, where by definition, obviously, the company doesn't have written authorization, but is approached by someone who it later turns out had stolen the identity. And then the person who's the victim of the identity theft comes forward and presents a claim and ultimately a lawsuit saying that the company who is using the stolen ID did not have a legitimate business need and so violated FCRA. It's an interesting scenario in the sense that the statutory language doesn't really address this. And when FCRA was enacted, identity theft wasn't as rampant as it is currently. In the context of the realities of business using these credit reports and the difficulties of identifying in advance who is using a stolen ID. The courts have recognized that it's a legitimate business need for the company to verify the identity of the consumer who's seeking service or seeking to enter into a transaction. And that's true even if the credit check fails to alert the company that there's been a case of stolen ID. There's a series of cases that are at the circuit court level involving Dish Network. It's a very familiar scenario where the perpetrator, the imposter, attempts to open a Dish Network account, and the legitimate business purpose is pulling that credit report under the name used by the imposter, and even if that fails to identify that there's been a case of identity theft, for example, the addresses don't match or the names don't match or there's some other discrepancy, that doesn't make for a FCRA violation. We also see sort of an argument that, well, you get one bite at the apple, and after that, if the account, for example, goes delinquent, the company can't do a subsequent credit pull. And again, that's a scenario where the courts have recognized that the purposes of account review can support that subsequent credit pull. The identity theft scenario is really important when the user learns that the consumer has put a fraud alert on the account, however, and the FCRA has specific provisions where a consumer who's been the unfortunate victim of an identity theft contacts the FCRA and identifies and asks for the fraud alert. And if that fraud alert's on the account, then that creates the duties on the part of users to take additional steps if they're going to engage in any credit transaction. So it's really it's a twofold scenario. The user of the consumer report is not sort of assumed to know that there's been identity theft. The exception is where the victim of the ID theft has taken that extra step and asked for the fraud alert, and that's been instituted. Could we go to the next slide? I'll say too that there's a couple of kind of blanket or threshold steps that you take as a user credit report that you might want to consider. One is providing a blanket certificate to the FCRA that you intend to use it for the purposes recognized by the statute. The idea there is it obviously lessens the burden on the business. It also creates an issue and litigation and a defense for the FCRA if they obtain that certificate. You're also, as a user, you're obligated to notify when you've taken an adverse action based on the credit report. there's obviously scenarios where you may take an adverse action and base that action on information that's not in the credit report. But FCRA also allows consumers to make a request and require disclosure of that information. So the sum total here is that your duties of using the credit reports really are triggered when there's an adverse action, and it will depend on whether that adverse action is based in whole or in part on the information in the report. The next slide, please. Young Soon spoke earlier about furnishers of information, and obviously companies in a variety of scenarios provide information to CRAs, and the statute is very clear that to file suit against a furnisher, a consumer has to first go through a formal dispute process that's initiated with the CRA, and that triggers a series of deadlines of 5 business days to provide notice to the furnisher on the part of the CRA, and then 30 days for the furnisher to investigate. And if there's a discrepancy, to correct the discrepancy back to the CRAs. This is a really critical requirement if you're a company that's furnishing information, because often, or too often, I guess, it's very easy to criticize the furnisher for providing information that's not correct, and the furnisher does have something of a safe harbor here, unless the consumer has proceeded in the first instance through the CRA, and so that's a critical consideration if you're furnishing information to a consumer reporting agency. And I think we'll go to the next slide here. This is
the next slide.
Natasha.
So I think we're going to...
Perfect. Go ahead.
Yeah. Next slide. Sure. No, I think we're going to run into now litigation under the CARES Act. As you know, in response to the pandemic, Congress enacted the CARES Act, and the purpose was to ease the financial burden on individuals and small businesses resulting from the pandemic. And Section 4021 of the CARES Act temporarily amends FCRA. And under this amendment, essentially, if an institution makes an accommodation and agrees to defer a payment obligation because of COVID, then the institution must then report such obligation as current. Now, an accommodation is a broad term, and it includes an agreement to defer one or more payments, to make a partial payment, to modify a loan or a contract. And the CARES Act doesn't indicate whether the agreement must be in writing or signed by the customer. The end date for this temporary amendment is also still unknown. Next slide. Now, there has been at least one CARES Act litigation filed relating to FCRA. In July of this year, plaintiffs in a class action alleged that defendants failed to adopt reasonable procedures to ensure the accuracy of consumer credit reports. The background here is that Section 3513 of the CARES Act automatically suspends all payment obligations on federal student loans held by the Department of Education from March all the way through the end of the year. And so as a result, student loan servicers such as Navient, in this case, they're required to report payment obligations as current. Please. So plaintiffs allege that defendants improperly reported thousands of federally owned student loans as being in forbearance, and which resulted in borrowers suffering a decrease in their credit scores. And based on the complaint, it appears Navient misreported the payment obligation and then tried to correct it. Then when plaintiff had procured her consumer report back in May of 2020, she saw that her credit score dropped by around 97 points. Now, her credit report was corrected, but her credit score did not adjust to reflect this correction. So the plaintiff alleged that defendants failed to follow reasonable procedures to assure maximum possible accuracy of the records that defendants reported. Next slide, please, Heidi. So basically where we're at in this case is that the plaintiffs filed an amended complaint in October, and the three defendants in the case filed a motion to dismiss the first amended complaint, and hopefully we'll see a ruling on that soon. Next slide. So in addition to increased litigation in the COVID era, with the Biden administration moving in, I think we can expect a ramp up of renewed enforcement actions with more investigations and potentially heftier fines. And you might have seen this little public spat that the state AGs got into with the CFPB earlier this year, when the CFPB announced it was going to relax enforcement standards on businesses during COVID if they couldn't investigate consumer complaints within the time period required by FCRA. Now, 23 attorney generals urged the CFPB to withdraw its statement and expressed concern that consumers would be discouraged from taking advantage of these accommodations that lenders are offering during the pandemic. It's also worth noting that there was a 550% increase in consumer complaints to the CFPB within the first 6 months of the pandemic. And many of these complaints are about the delay in investigating consumer complaints. Now, these same 23 attorney generals wrote the major credit reporting agencies, reminded them of their continued obligations under FCRA during COVID. And then our California Attorney General Becerra accused the Trump administration of failing to enforce consumer financial protection rules. And he noted that the state AGs would continue to perform oversight of the credit reporting bureaus. And this all sounds very familiar for those of you who follow data privacy. Attorney General Becerra took a very strong stance when he refused to delay enforcement of the CCPA, and this was when the CCPA regulations weren't even final. He pretty much dug his heels in and emphasized that it was even more important during COVID that consumers understand their CCPA rights and exercise their rights during a time like this. Now, with the Biden administration, we are seeing a change of the guard, and with the potential replacement of the current head of the CFPB, there will likely be a focus on consumer protection and enforcement of the CARES Act. It's also known that Biden has in the past forged very strong partnerships with the state AGs. That will probably continue. As you all know, Kamala Harris, as the vice president-elect, was the former state attorney general of California, as was Biden's late son. Next slide. Now, all of this points to really updating your compliance function during COVID. So you want to make sure your policies reflect these amended rules, that your employees are trained on accurate reporting of COVID-19 accommodations, that you're documenting cases of accommodations appropriately, and those agreements where individuals have agreed to such an accommodation. And while the CFPB's statement did suggest that it would exercise some flexibility during COVID, it also urged businesses to use good faith efforts to investigate disputes as quickly as possible. Okay, Mike, I'm going to hand it over to you to take us through litigation. And if we have time, I can go back to the willfulness and just a couple other slides.
Thanks, Natasha. That's great. We'll do. So, congratulations. You've been sued in a FCRA case. I'm going to talk about just sort of defenses in any case, and then also defenses specific to class certification. One sort of threshold issue is whether you have an arbitration agreement with the plaintiff. And I think there's been a lot of activity, obviously not only in the area of arbitration under the Federal Arbitration Act, but also specific to FCRA. There was a notorious case from the 11th Circuit that involved a claim that the plaintiff wasn't provided FCRA compliant disclosure when Waffle House did a credit check. the class action is filed in the district court and litigated for a period of years. And then Waffle House learns that they've not only did a subsequent credit check on the plaintiff, but they hired the plaintiff and he entered into an employment agreement that included an arbitration provision. And their motion to compel arbitration was upheld on appeal. The 11th Circuit reversed the denial of that motion on appeal, and a somewhat notorious decision because the case that had been prosecuted as a class action for a period of years was ultimately sent to an individual arbitration. So it's never too late to look for that issue, particularly in the context of employee background checks. Another key defense is a challenge to the standing of the plaintiff. I think folks have heard of the Spokio decision, which went to the Supreme Court under the FCRA. There's been subsequent decisions that have confirmed, even after Spokio, if the information was accurate or not really circulated to third parties and there was no adverse action as a result of the use of the information, but there's not the Article 3 concrete injury, there's not the standing necessary to sue in federal court. And the case that the Jarvis case is a more recent case, but the same proposition. If you've this was a decision after Spokio from the Ninth Circuit, it really stemmed the tide of a series of class actions that have been launched, just based on the theory that if you're discharged from bankruptcy, the reporting of the debt on the credit report violates FCRA. The Ninth Circuit was very clear that you had to allege some actual impact on a financial transaction that you were contemplating. If there was the obvious point that if you're discharged from bankruptcy, the bankruptcy probably is more relevant to lenders than the prior debt that was discharged. It really limited this sort of favorite play for class action lawyers. The issue of willfulness is critical in this statute as well. Natasha mentioned it earlier, but really, if you're a defendant and you reached a reasonable interpretation of the statute, guided by case law, guided by letters from enforcing authorities, in some cases, the summary judgment opening is potentially there for you. It's critical because so often the plaintiff's bar wants to get to the land of statutory damages to make the case very simple for the judge to find some sort of uniform practice that the defendant engaged in. It's common to the class, and that, in their view, was a willful violation of the FCRA requirements. It's therefore critical as a company operating in this sphere to keep up on the current events, the current developments of the law. If you've got a Ninth Circuit decision or a circuit court decision that's directly on point, then the plaintiffs can argue, well, you didn't adhere to that clear guidance that had come down, and you continued your operations without complying and acted in a willful or reckless fashion. Let's go to the next slide. I'll say really briefly, there's been a lot of interesting developments of the law here in the class action context in particular. There was a case from earlier this year where the Ninth Circuit affirmed that class members, if they're going to recover monetary remedies under FCRA, they have to have Article 3 standing at final judgment. Ramirez case was a class action that had been prosecuted for years in the Northern District of California. Went to a verdict, and why the Ninth Circuit embraced this theoretical proposition and affirmed on the grounds that the class members all had Article 3 injury. They had actual injury as a result of the alleged class-wide FCRA violation. But that issue is still critical for class action defendants to sort of bust the class on the notion that whether there's been actual injury, it requires individual determination. There's still an issue that we see of fail-safe classes and FCRA. It's so difficult as a plaintiff to allege the class membership to define the class at the outset of the case, that often plaintiffs define it as everybody who's been injured by defendants, a violation of the statute, and that ultimately falls apart at class certification. And I'll say just really briefly that in addition to individual issues, I think courts have recognized that the idea that there's statutory damages cuts against class certification, because figuring out the amount of statutory damages sometimes is an individual determination. And sometimes those statutory damages make a class device, not a superior means, so as to defeat certification under 23B3. At the Ramirez case is another example of challenges as well to imposing punitive damages or aggregate statutory penalties within the limits of due process. And in that case, the Ninth Circuit affirmed the verdict, given the class size and the scope of the penalties and punitives. But it's very much an issue if unfortunately you get to that stage of the case. So there's the FCRA class action defense strategy is actually not very different from defense strategy you see in other kind of statutory class actions, including the TCPA and some of the other ones that are the favorite of the plaintiffs bar. So we're at about 11:56. Yeah.
Yeah, we've been actually answering questions. Some people have been sending questions individually. Thank you for those. It actually looks like we have one for everyone. The question is, are contractors or independent consultants granted protection under FCRA? Young Soon, do you want to field that one?
Sure, and I think I addressed this briefly earlier. Although the case law is not uniform on this, if I am a company trying to decide if I should disclose the fact that I'm about to obtain a background report about an independent contractor or consultant, I would err on the side of getting that disclosure. There are cases both in California and New York where courts have ruled that that consultants and or independent contractors do have the protection afforded under FCRA. I will say that protection has been extended in certain circumstances, even to the situation where a company is using information they've obtained in a background report to nix the employment of a vendor or an employee for a vendor. And so the statute, depending on the judge, depending on your jurisdiction, can be extended beyond the employment, the employer-employee context. So I would exercise some caution in that context. And I would also say, and just to briefly double back, I think that the willfulness point really is worth underlining because of the standard for willfulness and how that really plays into the case law, particularly in the Ninth Circuit, about what arguably are clear standards for what can be included in disclosure and can't.
I think there's one more question to everyone. I'll read it now. You can you get an applicant's consent to the background checks before giving an offer of employment, with the understanding that the background check will only be conducted after an offer is made?
Sure, and I'm happy to take that one. With the caveat that you should be looking at the rules in your specific jurisdiction. Generally speaking, this is acceptable. And in fact, it is, I think, many companies' practices to actually include somewhere in the packet of materials that's provided to the employee consent to conduct evergreen background checks, kind of periodically throughout the employment. And so I think in principle, again, depending on your jurisdiction, this is acceptable. You do want to be careful about how those concepts are disclosed to the employee applicant, that they are clearly disclosed, and also we discussed that they're not disclosed in such a way that they kind of muddy the FCRA disclosure form. So those are some of the things you want to look at. But as a matter of principle, I would say yes, that is, you can do that if you disclose those concepts in the right way.
Okay, thank you, Young-soon. I think we're at the top of the hour. Really appreciate your questions and engagement. I'm going to hand it back over to Alex. I understand you might run the raffle one more time. Is that right?
Yes, thanks, Natasha. Thank you, Michael and Young-soon. Really appreciate it. Fantastic work. Great discussion. Yes, we've opened up the raffle again to allow folks who joined a little bit late to participate. Compliments of Akin Gump. We're raffling off a $150 Amazon gift card. I am fairly certain that whoever wins this will find something to spend it on Amazon. I think just yesterday I spent well over $150 on Amazon stuff. So just in time for the holidays, feel free and jump on the poll. While people answer the poll, that's got 38 seconds left. Just wanted to thank Akin Gump again. And thanks to Michael, Young-soon, and Natasha for leading us through a wonderful conversation today, and really informative and really, really well done. Like I mentioned at the outset, we're going to be getting our, you're going to be getting, and we're going to be getting our CLE certificates, the survey, and the slides. They're going to be available. Today's session was recorded for ACC San Francisco Bay Area members to be able to visit and revisit. So thank you all for your support. And I think the poll has now closed, which is great. And I think with that, we're done. So thank you all. And we'll announce the winner directly. And I think that's it. Thanks again. Have a fantastic week, everyone. Thanks again.
Thank you.
Thank you.
Thank you.
Thank you.
Appreciate it.